So Tony and I are going to be talking about joint ventures. We've done a number of them throughout the years. There was a large uptick in joint ventures last year, and I think that's going to continue for 23 and 24. We saw a similar phenomenon back in 08, 09, after the credit crunch. A lot of large strategic companies, instead of going out and outright buying divisions or expanding through through acquisitive M&A, they started dipping their toes in the water again by doing joint ventures and partnering up with others to test the market. We're also seeing a lot more as people are joining forces to take down transactions that normally they would go out and lever a little bit more. Capital markets are a little tighter right now. And so we're seeing partnerships form and joint ventures form to complete acquisitions. And so we're going to see a little bit more of that as we get into 23 and 24. And so I think this is just from a timing standpoint, just a great way to end out this year, kick off next year. And we'll go ahead and get started with that. So I'm going to turn it over to Tony to walk us through a little bit about knowing your JVs and get us started. But as we continue, we'll just dialogue. We invite you to as well. I know you're not allowed on camera or voice, but just use the chat. We'll answer whatever questions you have as we go.
Yeah, I'd reiterate that if anybody has any particular questions, we're going to be monitoring that. So please, feel free to send them along, and we'll take them. We'll also hopefully leave some time at the end for questions if people want to ask them at that time. Yeah. So in terms of what we're going to be hitting today, the first thing we'll do is just kind of give some key overviews. Know your JV. What are some major considerations you just need to be thinking about in terms of your company, what sort of JV you're going to be working with, who your counterparties are, et cetera. We'll talk about then kind of what I consider to be the three main aspects that are important in every single joint venture, which are, the economics, the governance and management, and then your, transfer rights, obligations, and your exit rights. So how are you going to monetize your joint venture, right? And then we'll also touch on kind of other key considerations that we think pop up in a fair amount of joint ventures.
Right. We'll talk a little bit later on about kind of the exit and the transfer rights. A lot of people think, as they're going into joint ventures, this is going to be, a partnership that lasts eternity. But unfortunately, most actually fail within the first 5 to 7 years. So we'll see. We want to plan for that as well. So.
The one thing I want to kind of get out of the way up front is, joint venture can be a pretty broad term. People use it in a lot of different manners. What we're going to be talking about here is essentially, two or more parties that are coming together to, form or invest in an entity to pursue a common goal. And so we're not necessarily going to be talking about, a joint venture that might be established through just a pure contract or, maybe say a joint license agreement or something like that. We're talking about entities that, most importantly, the operating agreements and the other documents associated with that and the key considerations in negotiating those.
Those former ones are often just referred to as virtual JVs. So if you ever hear the term a virtual JV, it's just two partners coming together through contract or otherwise to have a goal and work together on a project. These are more entity-based JVs where we're actually forming an entity and a partnership related to that.
So when you're starting off and you're thinking about what sort of joint venture you're dealing with, there are a couple different ways to look at it here. Who are the parties? Here we're talking about, breaking it down just a two-party joint venture, but obviously a joint venture can be as many parties as might be appropriate. But, very common structure is a financial partner and an expertise partner, right? So someone who's bringing, vast majority of the capital and someone who's bringing the expertise. So say, a investor and a real estate developer is a very common, financial expertise joint venture. A financial investor, two different investors who are mostly in it for the investment, obviously. Sometimes that will be, backed with a management team who's actually running the business day to day. They may or may not also have an interest in the joint venture. And then, strategic. So, two companies that are coming together, they have their separate businesses and, are not just purely from a financial standpoint. They might have specific long-term goals. They view the joint venture not just as an investment. They might have a longer term, outlook in mind here.
Right.
Another way to look at it in terms of your type of joint venture is the economics, right? And so, a very common joint venture is your 50-50 partnership. The simplest idea here is just two individuals are starting a business and they want to form an entity to house that business, right? You might also have, an investor, or sorry, financial joint venture might often be 50-50. Another very common economic joint venture here, majority minority, and that can be kind of across the board. It may be one investor who is putting up a vast majority of the cash and your expertise minority partner. We often see 80-20 joint ventures or 95-5. But you could often have a majority minority joint venture that is one key majority member with numerous different minority partners here.
Right.
And those could be both financial or expertise potentially.
And one thing to just keep in mind as you're going through the economics of this, make sure to loop in the accounting team early on, because there are some different rules and regulations related to which party can account for the joint venture from a consolidation standpoint. So whose books it's going to be on might be a key driver to some of the rules, governance rights and things like that you have. And so you want to tackle that early on just to make sure you follow through who's going to be accounting for this from an accounting standpoint.
And then another thing to consider here that we won't get into, a whole lot, because it's more of the business aspect rather than, the legal aspect in terms of negotiating agreements. But, what's the reason for the joint venture? And we've got a handful of different types of joint ventures from the business aspect. Your project-based joint venture. I go back to the real estate development joint venture. Is this a joint venture where we are building, one specific building or development? A functional joint venture? Are we, developing a line of business purely for this? A vertical joint venture, which is typically between, buyers and suppliers. So you might have a joint venture between, say, a large beverage company and, a bottling company.
Right.
And then a horizontal joint venture, which is essentially a joint venture between two companies or two entities that are in the same line of business. And obviously, one thing to be particularly concerned about with that type of joint venture is any, anti-competition or antitrust issues.
Right. A lot of times they come together, it's either, as you've pointed out, it's either an investment kind of building, you're getting financial backing to do something like oil and gas exploration or real estate development. Sometimes on the strategic side, it's mostly almost like IP generation. So technology is a massive driver of these JVs. And so those fall into more of the project joint venture, but they're trying to expand into a new product line, for example. One that I worked on, we won't use a lot of client examples, obviously, unless they're public, but Essilor makes eyeglass lenses. They partnered with PPG 20 years ago, the paint company, to make photochromatic lenses. So they're branded as transition lenses. When you're inside, they're clear. Outside, they turn into sunglasses. That was a joint venture. It lasted about 20 years. So it can be strategic in that way of coming up with the IP. But at the end of the day, you really got to determine who's going to own what if this thing were to separate, and where that IP, what it can be used in other areas too. So.
Yeah, a very common joint venture I see in my area, particularly in the energy industry, is what we'd consider an upstream midstream joint venture, where you have an oil and gas producer who needs to get their hydrocarbons gathered and transported, and so they'll form a joint venture. They'll dedicate all of their acreage to a specific midstream company, and that midstream company will grant some sort of equity consideration in the entity to the upstream producer to go out. So they have both kind of a contractual arrangement with that entity as well as equity in it. You typically see that given for people who are kind of early movers to sign up with those midstream companies.
Yep. All right, let's dive into some of the key documentation, deal terms, and kind of getting into the nuts and bolts here a little
Sure.
bit.
So yeah, just kind of an overview. I mean, the main document you're going to be dealing with in a joint venture is the operating agreement. I mean, typically from my perspective, I'm working with private capital a lot, and so that's going to be an LLC agreement or an LP agreement, and this is going to contain, you know, a vast majority, if not almost all, of the terms that we're going to be talking about today. You know, everything from the types of securities that are issued, you know, the economics, the governance rights, fiduciary duties, you know, any potential restrictive covenants, exit rights, information rights, you know, all that sort of stuff. The other things that you might see in a joint venture, and you don't always, is, you know, a management incentive equity plan. You know, a joint venture could simply be a private equity investment in, you know, with the new management team, in which management's getting incentive equity and the private equity firm's putting up, you know, capital dollars here. But it may be, you know, you may have a joint venture in which the management team is kind of completely separate, but there is a management incentive equity plan that needs to be dealt with. You know, a lot of times commercial agreements are entered into between one of the partners in the joint venture. And then a lot of times you'll also see services agreements or a management agreement. So, you know, one of the parties has the expertise, they have the experience here. You know, this is very often the case in a financial expertise joint venture, where you have an outside entity that is owned by one of the partners who has a services agreement to run the actual operations of the joint venture.
Yep. It's funny. Sometimes the economics that flow through these joint ventures is more in the supply and the services agreements than it is the JV itself. So you might have it's just a supply agreement on the side, but there might be, you know, millions of dollars that flow through that, as opposed to, you know, just a smaller portion of that through the JV itself, through the dividends. So
yeah, that's a good point. When thinking about your economics, particularly from a business standpoint, you need to look at the whole picture, right? It's both what is the equity you're potentially investing and what the value you're getting out of that, but also, you know, what is the value you're getting out of the commercial agreements. And we'll certainly see, you know, provisions given in services agreements, you know, for, say, you know, a trade-off on the operating, you know, in terms of the operating agreements.
Yeah.
You know, very common joint ventures, obviously majority, minority. You know, certain when you come in at the beginning, it's on, you know, you need to take consideration of, you know, what are kind of your goals based off of whether you're in the majority or minority position, or, you know, this will obviously be different from a 50-50 joint venture position. But as a majority, you're obviously seeking control of the governance and the management, excuse me, as well as any sort of exit scenarios. You know, at the minority side there, you're looking for, you know, we want to have a say in certain key specific decisions.
Right. And you're really just trying to protect your interest in that minority position. So look, instead of, you know, we're both controlling this, you know, we appreciate you're controlling this, but we're coming in as an investor and we want to protect our minority rights. You can't sell things out without us. You can't do, you know, you can't dilute us further or stuff like that. Those are those control issues, you know, are key drivers for a lot of this.
Yeah, and if we have time at the end, we may talk about kind of some specific situations on what level of minority, you know, investor would receive, you know, what specific rights.
And that depends on the industry, you know, but we do have some general ones. I'm just thinking, you know, going back to the start, I do a lot of sports deals. And so a lot of sports teams are owned by a majority controller. And then they have a lot of investors that are owners in the team, but only have certain, you know, protection rights throughout. So it's in essence a JV in that context.
Yep. And in terms of equity from a minority standpoint, you're really just making sure that, you know, to the extent there is an exit transaction or the majority partner is exiting, you're going to be able to participate in that, as well as have some sort of defined path to liquidity, whether it's, you know, a horizon in which you might be able to cause an exit or a put right or something like that. We'll get into that a little bit later. You know, you'll see here types of securities, timing, nothing too out of the ordinary here, but, you know, minority investor may have a different, you know, non-common equity structure. And then in terms of due diligence, you know, it's robust due diligence, obviously, from a majority transaction to the extent this is an existing business. But we will see, you know, minority investors do fairly significant due diligence if they're coming in, you know, for an investment in an existing company. It's a later stage in the life of that company.
And rep and warranty, I know you've had we've had other trainings on that earlier this year, but obviously that drives a little bit of the level of diligence that's done.
So getting into the economics, typically with a joint venture, especially for a newly formed joint venture, there's going to be some sort of initial capital contribution by the parties. Often it will be it'll be just cash, if it's a company, a greenfield company that's going out and developing a line of business or a specific asset, but it may also be a combination of cash and property. And so one thing I think that's important here, if there's ever, at the beginning of a joint venture, if there is, property consideration, typically if it's both entities contributing property and not much cash at the beginning, you always want to make sure you're setting proper valuations for that property, because that will help govern and, set a fair standard for future capital coming into the company.
Right.
So you want to make sure you're not getting shortchanged or, giving too exuberant of a value for any property contributed at the beginning.
Right. And that property might be IP, so sometimes it's hard to value, right? You need to kind of work through it, but obviously you can, third parties like Stout and others do an excellent job of valuing these businesses and what assets you're contributing in, so.
Yep. And then obviously there's the question of additional capital that's going to be put into the company. One thing that I probably should have said at the beginning here is that joint ventures can be as simple or as bespoke as you really want them to be.
Right.
And so your options are sort of endless. We're going to kind of hit here on what we typically see in obviously these key considerations, but you may have a joint venture where neither party is required to put in any additional capital at all. That would be atypical, I think.
Right.
But it's certain, we certainly see them in the markets. But normally there is some requirement to put in additional capital by both parties. We typically see that based off of existing ownership splits, but it doesn't always have to be the case. A lot of times we will see parties make a capital commitment to the joint venture, right? So they know, listen, we are going to be required to put in X amount up to X amount of dollars. And, after that it's going to be at our option. But, there may not be a capital commitment. There may just be, listen, under certain scenarios, you're going to be required to put in capital. And that could be in accordance with an agreed upon budget.
Yep.
It could be, for certain specific, scenarios in which, there's a need for that capital. Obviously, we've got emergency expenditures, non-controllable expenditures, those sorts of things. So those are often required capital contributions, but not always.
Yeah. This is one of the reasons I love JVs, because at the outset of the joint venture, you got to kind of think through the whole life cycle of the business, right? You got to think through not only how are we forming it, what's going to happen. You have to work through kind of, all right, well, how are capital contributions going to be done in the future? If 2 years from now we need more money into this, how are we going to do that? And then later we'll talk about it, but you have to think about what happens, if there is an exit or it dissolves. And so I just enjoy it because it's a real opportunity to kind of flex internally with your organization to think through, how has this worked? How have we done in the past? What other areas could we improve upon? But what other things should we be focused on? And that's, the business teams are always, oh, this thing's going to be great. And it'll be wonderful. We're going to have this new product and we're going to sell it, or we're going to have this real estate development, or we're lo and behold going to find oil here. It'll be great. You as the council need to sit them down. And this is where there's real value add, is to really think through a lot of these issues and work through capital contributions, exit rights, voting rights, governance, things like that. So, yeah. Anyway, go ahead.
And to be honest with you, from the legal standpoint, because kind of the possibilities are endless in terms of the types of provisions you can have in your joint venture agreement, it does allow for a lot of creative problem solving.
Yeah, it's great. It's great. And the beauty is, as the JV continues, it's not like you just bought the business and now you're running it. There's continuing legal questions and work and advice and responsibilities as it's going through its life cycle. So it's awesome. So
moving on a little bit, the question is, whether or not what scenarios and how much capital you might be required to put into the joint venture. The question is also, what happens if you either don't want to put in additional capital or you may have been required and, aren't able to, right? And so, I think there are certain, the remedies for this, in my mind, as again, you can kind of get as complicated as you want here, but there are two specific scenarios are you not funding a required capital contribution or are you not funding an optional capital contribution? And in most scenarios, if you're not funding an optional capital contribution, that's just going to be pro rata dilution. Now, that's not always the case, but I would say that is a vast majority of the case for optional capital contributions. If you have $100, the other person has $100, and you don't want to put any more money, then they put another $100. Well, you're going to go from owning 50% of that joint venture to a third of it.
Right.
But for required capital contributions, there are a lot of different options that we'll see here, and they're typically fairly punitive. And this also gets back to what sort of joint venture we're talking about. If we are in a scenario in which one member is able to essentially control when capital contributions are called, then, if to the extent that it's a required capital contribution and, the non-funding member doesn't make that, or there is a non-funding member or partner here, the options, you'll often see the funding members be able to make a loan to the joint venture with, punitive interest rates, or potentially a loan to the limited partner with punitive interest rates, so that any distributions that would have been made to that non-funding partner, go to offset that loan. You may also see, not just punitive interest rates, but say any distributions that are made on, or any capital contributions that are made on behalf of the non-funding partner, those partners get some sort of multiple on their capital before the other partner, starts participating in distributions all again. And, you'll see that.
Very creative on all these.
Yeah, exactly. We see that we have 200 to 150% potentially. I see that, sometimes in the energy sector go as high as 400%.
Yeah.
You also might see a scenario in which if a member's not funding their required capital contributions, there's they have their interest reduced, fairly punitively. You see it cut in half, or the option for maybe the other partner or partners to buy them out. Typically for
An
cost,
exit trigger.
or sometimes even a less than cost.
Yep.
Let's see here. So then kind of continuing on the flip side of capital contributions, you've got, your distributions or your dividends, right? And so talking about, what sort of assets that can be distributed. Obviously, cash can always be distributed, but sometimes you may have property being distributed.
Mhm.
I'd say that, that's obviously a little bit more atypical, but, the most common scenario we see, right, is everyone has everyone has a capital interest, or sorry, not a capital interest, common interest or common units in a joint venture. And, it's just distributions are just made based off of the number of units you own.
I think the one thing that I would flag here, early on, and we're trying to flag things that you want to be thinking about initially. Tax distributions, right? You may have some phantom income that's generated through the partnership. And so during the course of the years, you may have and be allocated profits and have taxable gains that you have to actually, come out of pocket and pay taxes for. The question is, does the JV itself actually distribute out to the extent it has it, available cash to help its members pay those tax burdens as it goes on. So make sure that again, we're not tax lawyers. We're not even playing them on TV. So bring in the team and make sure that you're thinking through that as well. And it'll change organization by organization what you need to do on that one.
Yeah, I think this kind of goes in line with tax distributions here too, is thinking about when will distributions be required?
Correct.
So if it's a 50-50 JV, a lot of times it's both parties have to decide, when to make a distribution, but you may have a provision in your operating agreement saying to the extent that there is available cash to distribute, it needs to be distributed annually or every quarter.
Yep.
And so certainly, that helps, particularly if you're a minority partner in these joint ventures, making sure that money is not just sitting there if you're concerned about, receiving the benefits of the cash flows of the entity, sooner rather than later. And the other thing we'll talk about in joint ventures is that, in terms of the waterfall and kind of the capital stack, you can get as complex as you want here, just like really any entity. The one kind of common thing that we will often see, say, in a financial expertise joint venture is that there is kind of two classes of equity. You've got your common equity, and then you've got your incentive equity or your back end, so that, the financial partner and the expertise partner are heads up for their common equity. And then after the financial partner receives a certain, preferred return, whether it's IRR based or just, return MOIC or ROI based, after that time, the kind of distributions split to give the expertise partner kind of a higher amount of those distributions or some sort of back end, right? So, a lot of times you'll see, say, an 80-20 back end after preferred return has been hit.
So, and you can modify these in any number of ways. So just, it depends on the economics that you're shooting for and the incentives. That's fine. I think we can move on.
Yeah, the only other thing I would add there is just, to the extent you are getting complicated with waterfalls, obviously you might want to make sure you bring in a tax attorney here to make sure there are no adverse tax issues to you or your partners. And the last thing we'll talk about in economics is just issuances of new types of equity, right? So in virtually every case, each joint venture partner is going to have preemptive rights that will be subject to kind of standard exceptions.
Right.
Those exceptions are, grants of equity to management, or in connection with key services agreements, or in connection with kind of fundamental transactions. You may have conversion protection rights. That's not really common, or that it's not standard for common equity, but for convertible notes, preferred equity, it may be. And then, when can you grant new classes of equity? That's often something that we'll see. We'll get this a little bit governance, but where, minority investor or minority partners may have, blocking rights there as well. The next place we'll go to is governance. So, the main thing here to think about is, what type of security do you own?
Right.
What is your overall ownership percentage in the company? Are you a passive or active investor here? And then obviously the context of the transaction matters, right? Does your company have more leverage here to be able to negotiate something that may be a little more off market or atypical?
Yeah, all of it is, I think that's the main driver, right? It's kind of, as we're talking about governance, we're thinking about, all right, now we've formed it. We've talked about the economics, how that's going to be shared. Now let's think about the actual running of the joint venture. Who's going to make decisions? How is that going to be controlled? What protections does each investor have in this? Each partner as they're going through this, and so a lot of that just is very bespoke for each joint venture. There's some commonalities as well, but
yeah, the one thing I would say from the corporate counsel perspective is, you obviously want to get the operating agreement right and make sure that your client is well protected and has the legal rights that they need in the documents. But you also really need to be thinking about the day-to-day aspect of the joint venture and how is it going to run, because, very often, as we as lawyers know, you will negotiate a long form operating agreement, and that agreement may just be put in the drawer and not looked at until something really big happens, right?
Correct. Yeah.
And so making sure that what we have in the agreement marries with the expectations of what's going to be happening from a day-to-day standpoint is very important.
Yeah, and some of it may just be jurisdictional, right? So you want to make sure that you're following what the local trends are, and we're not really, a lot of this is focused on U.S. deals, but I had a client that did a joint venture in China, and elaborate, gorgeous governing documents and thought through everything in terms of how the economics were going to work and the structuring, the board structure and this and that. And the other side really just wanted to make sure that they had the opportunity to appoint the manager at the facility. Well, it turns out in that jurisdiction, in this one province, if you're the manager of the facility itself, you have total control over the financials, the economics, the books. And they literally just locked out their JV partner and gave them no financial information, no nothing, and controlled the whole JV just from just from the ability to appoint the manager at the local facility. So anyway, you just got to be careful about how all these.
Did the rules of that local jurisdiction essentially override their contractual arrangement?
Correct.
Wow.
Yeah. So you got to be kind of mindful of that as you go through. But we're here to set you up for success. But you got to think through a lot of these things. But there is that kind of overarching aspect in the background, the context of the transaction, and the leverage that each party has may be slightly different from what's in the governing documents than reality. So just kind of work through that.
So,
yeah,
in terms of governance here, key considerations you're thinking about, very often a joint venture is going to be run by some sort of board that the partners will have the right to appoint either, members or directors to that board or potentially observers. If you thinking about it, from a minority investor perspective, if you're getting to, between 10 and 20%, I think you're going to want to have some sort of representation on the board. Below that, you're not necessarily always going to get that. From a majority perspective, obviously you want to make sure that you are controlling that board, subject to maybe some key, minority protection rights on certain actions here. Another thing to think about here, right, depending on your joint venture, will there be, subsets of the board or committees formed? Obviously, you want to take into consideration and make sure that your protections extend to any sort of committees that might be designated power from the board. Negative consent rights is kind of a key aspect of joint ventures, particularly when, it is a majority minority joint venture. There's a laundry list of items that you can ask for here, and we'll get into them a little bit more detail. But things that come to mind initially, rights over having a say in the budget, any sort of fundamental transactions, whether that be acquisitions, dispositions, mergers, et cetera. And those may be of a certain size, potentially, borrowing amounts, those sorts of things, and then, interactions with management. And then information rights, those are obviously just a key one to think about. You want to make sure that your company is, particularly in a minority context, that you are, as Mike, had the experience in one of his deals, you're not the party getting frozen out of all the information, right?
And this, especially if you're, a public company going into a joint venture, you have obligations for reporting. Even if you're a private one and you have other investors that you have to report to, you want to make sure that you're getting the information. It's not just a siloed business that you have no insight into. So I think that's key.
So here, negative consent rights, obviously this in any sort of kind of, non-50-50 joint venture here, in which it's not just both parties have to agree upon everything. This is a key aspect of the negotiations. I talked about these a little bit earlier, but issuing equity or debt, significant transactions. One thing that I always like to, really make sure I zero in on and understand when I'm negotiating these is affiliate transactions. Mm-hmm. Because obviously that's a way that, say, a majority partner or the person who is running the business could potentially, move the economics out of this joint venture. As a minority investor, you want to make sure that, or a minority partner, you want to make sure that at the very minimum, affiliate transactions are going to be on arm's length. Ideally, if you're a sizable minority investor, you might want to have a blocking right over those.
Right.
But it does kind of depend on the situation.
I often refer to it as leakage, right?
Yeah.
So they're taking economics out of your joint venture for only their benefit. Some of it's prearranged. We talked about those supply agreements, services agreements, support agreements. Some of that is completely necessary and upfront and expected and benefits the joint venture. Some of it is a little more opportunistic. And so you want to just make sure that, if there is a decision to bring in, an IT consultant to revamp all of the data centers for a business, that doesn't happen to be the JV partners, side business that gets chosen for that. So you want to make sure that the economics are being honored throughout. So I think.
Yeah, and oftentimes you'll also see, to the extent, let's say it's a multi-party, so 3+ joint venture, and you have a board that has, people who are appointed by each of the parties. You'll often see those members who are the members of the board who are conflicted not be able to vote on affiliate transactions or other kind of conflicted interest transactions here.
And so in the governance, you're really just looking for, one is insight, knowledge, information, awareness of everything that's going on. Whether that's through the board as an actual voting member or observing rights, information rights. So you want to have knowledge of everything that's happening. And then you want to have certain protections, right? So you want to have veto rights on certain actions and that's true even in a 50-50. Right? You can have a situation where a 50-50 JV, certain actions are just, look, they can only happen if both of us agree. You can also sometimes, I've seen alternating chairs. So if you have a board, the number one rule of all boards when you're putting them together, you hear, well, you have to have an odd number, right? Because you need to have that tie vote. Well, if it's a 50-50 JV, we're both going to, set the same numbers of people on the board. You might have an alternating right to appoint the chair. And so maybe this year I appoint the chair and she is in charge and is the tiebreak for any deal. Next year you get it. And so we flip back and forth. That's another way to kind of adjust that. But the governance and the rights come down to that, information and control.
Yeah, that kind of is a good transition into the next slide here, which is deadlocks, right? And so you'll often see this in these sorts of provisions in a 50-50 joint venture.
Right.
You may also see them in, majority-minority joint ventures where the minority partners have, significant negative consent rights.
Yep.
So, what we're talking about here is a scenario in which the joint venture needs to act, but is not able to come to a resolution, right? And so, there are various different mechanics that you can use here. We'll also talk about some of these, I think, when we get to transfer and exit provisions. But, simply just setting time aside for, say, if we are at a deadlock, okay, well, we are going to negotiate on this for, a week or 14 days or something like that. You may also have a built-in escalation provision where it starts with the board, but if the board can't make a decision, then each of the partners escalates it to, someone higher up than those who are sitting on the board.
I've seen that work really well because you said the board's supposed to figure out the solution. They can't, they get deadlocked. There's some contention there. Okay, so then it breaks away and it goes to the, each JV partner's VP. Right. And so they duke it out for a little bit. And if they don't resolve it, maybe it's the head of that division. If they don't resolve it, it has to go all the way up to the CEO. Well, no one wants to go to the CEO and go to her and say, we can't figure this out. We can't find a solution, because she's going to turn to you and say, well, figure it out. Get it solved. Why are you dealing with? And so I've found that while it seems, kind of benign, it actually has a really strong impact of getting people to the table and figuring things out. So there's a number of different deadlock provisions. That's one. I think the escalation works well. We talked about having alternating chairs. There's a lot of kind of tools and tricks you can do on this. You can do the 3 strikes, if the board is unable to resolve it for 3 meetings in a row, then something happens, like, you can get maybe an exit right, but you can get very creative with these as well. But that this is where parties tend to sometimes think a little too rosy as they're going in, we won't have any issues. Don't worry about it. You really got to put some time and thought into what's going to be happening related to when we can't decide or we can't agree on something. Something else, and I'll bring it up later. Don't worry about it.
Yeah, and I will say, we very often also intentionally see no sort of deadlock provisions, even in 50-50 joint ventures.
Mhm.
And, the idea there is, listen, if we can't agree on it, then each party, at least at the time where they're negotiating these documents, would prefer that an action not be taken.
Right. And just if it's that important, you're going to come up
Yeah,
with a solution related to it.
Yeah, the assumption, right, is that this is a business and everyone is ultimately going to be, at least somewhat reasonable with respect to it.
Right.
And so that, there's always a solution to be had.
So it's great. All right. So transfers and exits. So let's dive into a little bit of the ability to transfer your economics to get out of the JV. Alluded to this before, but statistically, and I hate using stats because they always change. But I've also had the opportunity to work on JVs that have been around for 20 years, 25 years, and are going strong or are in the process of dissolving. So sometimes you just got to think through a little bit of the exit sides. A lot of people ask me what's the number one reason that JVs fail, and it's simple. It's corporate personalities. Some corporations, just like individuals, just have a different way of looking at things. And if you don't match up on that, you're going to have a real struggle as you go through the joint venture. So these are important things. All right. So
And one thing I would add there too is, know from the business folks in your company, as well as, your other partners, what is the anticipated timeline, right?
Right.
Like, do you have financial investors who are coming in and they want to see this thing exit in 5 to 7 years?
Yep.
Are you a public company who could ride this out for decades? It's important to know, particularly when you're negotiating these transfer and exit provisions.
Yeah, absolutely. All right. So transfer restrictions, a lot of it is your partners are your partners as you're getting into this. And so you don't want them to just, lo and behold, transfer and bring in a new partner. Going back to something I just said, which is the corporate personalities, if you have a different investor base or a different set of partners than you thought you were getting involved with, that can change the dynamics dramatically related to your joint venture. So you want to have some thought and controls related to transfer restrictions. Some things that are always or generally accepted, affiliates, estate planning, moving for your personal economics, moving the interest around is something that should be permitted, right? Your partner should allow some flexibility for that. It's bringing in third parties and transferring that. You also just want to be mindful of the typical, aspects of investments. Can you do an indirect transfer? Are those restricted? Who approves it? What are the rights related to that?
Yeah, one thing I do want to point out is we've certainly seen recently issues with indirect transfers. And so one thing to keep in mind when you're writing these transfer restrictions, and if it is a concern of yours that your partners do not, transfer to third parties, making sure that, because you don't necessarily have contractual privity up the chain with your partners, making sure that there are punitive provisions in your operating agreement if there are any sorts of indirect transfers is very key.
Yep. And those indirect transfers can be somewhat, I don't want to say cute, but creative, financially structured, right? So you got to be mindful of how people are going to work through that. And part of it is it may not even be the individual you're working with. It may be their economics. So you've incentivized your partners in a certain way. Well, if they maintain their equity but transfer off their economics, they're no longer incentivized, and that changes the dynamics as well. So you want to be careful of that. All right. So there's a lot of protections, and a lot of these are driven at either chilling transfers, prohibiting transfers, or getting to join the transfers, right? Or and the inverse of that is causing a transfer. ROFR and ROFOs, we've all dealt with these in other contexts, and so that's something to work through here as well. A ROFR, to kind of take a step back, a ROFR is going to have a more chilling effect because I want to transfer my interest. I go out and find a buyer. I have to take it to you, and then you say, "Well, wait a minute, I'll go ahead and buy it for that." And
I don't know about you. I hardly ever see ROFRs anymore. If you're going all the way for a ROFR, it's almost, I see more often just a straight block.
I do see it. I do see it every once in a while, but it's I try to limit them as much as you can, because no buyer is gonna say, "Hey, I'm gonna go out and spend money on diligencing and come up with a purchase price just so I know my deal is gonna be taken to the other JV member and bought out." So what you'll see more often is the ROFOs, which are, look, if you want out, fine. Just give me the opportunity first to buy you out. And then if we can't come to terms, then you can go to a third party and we can have maybe I get a match, but you can go to the third party in that context. So the ROFR is going to chill it. The ROFO is going to keep it a little bit more flexibility for that. And it might change on classes and everything else. Okay, so tag along rights, similar structure as well. Look, if you're a minority owner, a minority JV partner, you're going to be more focused on these tag along rights. And you want to focus on the idea that you can't have other partners sell out and get liquidity and leave you in the dust with this new owner, especially if you didn't have control over who the new owner is or who the controlling, partner is. You want to have the ability to tag along on that. And so you'll again negotiate, what if they're only selling a certain percentage of it? What if they're selling, only certain equity that they have, not all of it? Do I get to participate alongside? Does everybody get to participate? So the tag along is something else that you're going to have to work through. And again, you'll have the standard, a lot of these ROFRs, tag alongs, drags, all of that stuff. Well, I guess not tags, but you're going to have exceptions for affiliates and for internal transfers and things like that. All right, so drag along is in essence the opposite of a tag. I'm a majority control owner, or we've got a JV with a bunch of different partners, and a bunch of us get together and we say, you know what, it's been a fun ride. It's time to sell this business. We need to get liquidity and move on. You can drag the other members along that sale. There's limitations and restrictions. They're not often utilized, in part because the buyer doesn't want to rely on the drag. They would rather that they get a clean title and have all of the sellers on board to do this. But the drag is definitely a stick that allows people to bring people along and force a sale when they may not otherwise have wanted to do that. Another area, a little less common, especially in today's markets, IPOs, registration rights. Your idea is so great, it's going to go public. Congrats. So that's a whole nother area that you need to kind of work through and think about as you're going through the exit rights that you have.
One thing to consider just as a minority partner in any joint venture, particularly if you're kind of a significant minority partner, is, it's standard to be, to have the majority member be able to force a sale of the company, including through a drag along. But do you want there to be certain parameters on that, right? Do you want the drag along to have to, achieve a certain return of your capital, or does it need to be, after a certain period of time, et cetera? So right. There's certainly, as a minority investor, you can kind of think through, well, all those sorts of things are standard. Can we put maybe some roadblocks on this to make sure we're just not, being forced into a bad deal? Correct.
And that you have your right, your rights to actually get out, either put your rights or call your rights. So I'm going to move on. If we can go to the next slide, which is put and call rights, we'll do that. I know we have a question in the box, so if you can kind of review that a little bit. All right, so one of the things we talked about is you got to think through the exit of the JV as well. And part of that may just be, look, at a certain point in time, if certain events happen, I have a right to put my interest to the other JV partners, or if it's a 50-50 to the other partner. So that's a put right. Call right is if certain triggers have occurred, I have a right to acquire your interest as well. Maybe we have we have mandatory capital contributions and you haven't done 3 in a row. I can buy your equity out, so I can call you. And so a lot of those are mechanics that you want to think through at the outset. The biggest issue, of course, is how do you come up with the price? And if you're doing a joint venture that's going to last 5 to 7, 10 years, it's really difficult, especially if that's an operating business in and of itself. How are you going to come up with upfront the price? And sometimes you might just be silent as to the price and leave it to negotiations later. I've seen exit provisions, and we can go on to I'll go to the next slide here. I've seen exit transactions, provisions in the governing documents that are literally 15 to 20 pages. And I've seen them that are 1 paragraph. And so sometimes it's intentional to leave something for later in order to bring the parties to the table and negotiate it, especially sometimes when it's so complex later on, you're going to want to manage that now. So I know we have a question in the box.
Yeah, so I think it's a good time for the question. And the question is essentially, how do you frame a request to the opposing party or parties for more permissive transfer rights? For example, a shorter lockup period, the ability to indirect transfer, from our looks like this question's from Matt. So Matt says his experience always invites scrutiny from the other side. And I mean, not to be a lawyer here, but it's always kind of situationally specific but what I would say is, if you are, if the idea is that you want the flexibility to be able to transfer your interest, I don't think it's harmful in letting your counterparty know necessarily, right? I think the idea here is that, and it depends if let's just say you're a minority investor or a minority partner, but you're not necessarily a strategic or an expertise partner, you're just a minority financial partner.
It's an economic play.
Yeah, then I think typically there's a lot more of there's a lot more leeway to do so, but you might be subject to, a tag along, right? So that everybody can participate.
Right.
Or, the ability to indirect transfer.
A ROFO kind of thing.
Exactly.
And probably a ROFO. I think if it's an economic interest and you're an economic player, I think the messaging is simply, look, this is the business that I'm in. I'm making this investment so that later I can move on. If it's more of a strategic, opportunity, you can be upfront with your partners and say, look, down the road, I am going to want to create some liquidity here and either bring in other investors that I think are going to help us. And so I'm not going to sell all my interests. I'm just going to bring in other investors and other partners that I think are going to help us. Look, I know at some point my board needs the flexibility, needs the thing. Not sure I'm going to trigger it, but we need to build this in today. So that's how I'd frame it up. And as you're going through that, we'll just quickly touch on exit mechanics and then a couple of other considerations. But on the exit mechanics, there's a lot of triggering events. It can be temporal, right? In 5 years, we're going to look at each other and say, hey, are we re-upping this JV? And then every 2 years thereafter, you can do that. It can also be event driven. Maybe there's management deadlocks. Maybe there's a failure to achieve certain milestones. Maybe it's not even anything related to the JV. The JV's been going great, but your partner experienced a change in control and now they're owned by your number one competitor. I don't want to be in a JV with my number one competitor. So that's a triggering event. So you got to think through all these different possibilities related to events. And then exits, is there a put call? Is there a buy sell? Is there an exit, termination, joint, exit rights that way? The other key considerations, I just want to quickly flash up and then we'll open it up to questions because again, I have a hard stop at 1 o'clock for the match. So very quickly, as you're going through a JV, are you wedded to the JV? Or are you, are you able to also compete and do other related things? So that might be a big thing. And then the other real big one is ownership of the IP. The JV might be creating additional IP. And so who gets that? Is that something we get perpetual rights to jointly? Is that at the exit, I take it, you don't, I'll buy you for it, things like that. So, so all of that would work. There's been a bunch of questions. Will we circulate the slides? Absolutely. We'll get those around to you so that you have them. I think this video is also going to be posted so that you will have that.